I want to jump into a little more nuanced, some questions for California employers of everybody on the webinar here today. We'll talk about that. And I'll hand it over to Mike to talk about the employer obligations created by school closures under California law.
Thanks, Anthony. So whether or not you qualify under the FFCRA for the paid sick leave or for the FMLA, you still need to consider separately under California law whether the employee may be entitled to unpaid leave under Labor Code Section 230.8, which the Labor Code provides up to 40 hours a year of unpaid leave for employees for certain school-related activities. And two of those school-related activities are school closures and natural disasters causing the employee to need to take care of the child. This applies if you have 25 or more employees at the location where the employee works. You have to provide this leave. Again, it's unpaid leave, but it's greater than the FFCRA in that it can be used by grandparents, step-parents, foster parents, not just limited to your son or daughter. If you have two employees, if you have the mom and the dad both work at the location, only one of them can use it. But again, 25 or more employees, you have to provide up to 40 hours of unpaid leave, and you can't retaliate against employees for taking it.
Great, thanks. And then, Anne, I know we get a lot of questions too about what can you do if an employee is fearful about coming to work during this time, even if you do have, your business does qualify as one of these essential services and you're open for delivery or takeout at a restaurant. What are employer obligations in that regard?
Well, there's no legal obligation to permit an employee not to come into work just because they're fearful of doing so. Obviously, you can be flexible if it's not going to cause a hardship. If it's going to start causing a hardship because you have so many people saying, I'm afraid to come into work, you obviously need to take some actions, document that, and explain to the employee that, look, you either have to come into work here or this is going to shut me down. The CDC has published guidelines as well in terms of employees who appear to have symptoms, and you want to encourage employees who have symptoms or feel sick to go home. If an employee has symptoms and asks to go home, absolutely they should. Keep in mind that if you, as the employer, are requesting the employee to go home, reporting time pay is going to kick in. But being fearful on its own, there's no lawful obligation that I'm aware of yet that permits the employee just to stay at home.
Okay, and we're getting some questions in, going back to the FFCRA. I think we'll handle that here since it's fresh in everybody's mind before we move on. But we get this question a lot. What's the difference between a layoff versus a furlough of staff? There aren't legal definitions of that, but generally speaking, if you lay somebody off, it's due to lack of work. It's not a termination for a cause or anything, it's just lack of work. Versus a furlough, a lot of people use that term as a temporary suspension of the employee from work, and they're expected to return. So now with the furlough, though, it's important to approach that. Just because it's temporary suspension, there's an argument that the employee would be owed all of their final wages and any accrued and unused vacation at the time that they're furloughed, even though if they're expected to come back in a short period of time. And Mike's going to talk about that here in a minute too. Under WARN, even if you suspend the employees for a couple of weeks and expect them to return to work after this COVID-19 passes over, it could trigger WARN issues, even though they're just temporarily furloughed. So that's an issue. And then in terms of the FFCRA and the paid sick leave, I think it's important to document what's really going on with the employee. Are they just being suspended for now, and they're going to be expected to return to work in a few weeks, and make that clear on what date they're actually being suspended from work, and whether they're being laid off or not. So if they're being laid off, typically that means that there's a separation from work, and you're going to have to process all of the end of employment paperwork, notice for reason of change in relationship with the employer, all the final wages, all that type of stuff. If you just do a furlough, it still means that they're on the books as an employee. They're just being suspended from work for a short period of time until this passes, and then they're going to come back on and get work in a few weeks. It's important to document that. One, for the paid sick leave reasons and the expanded FMLA leave, it's important to note that they're not being asked to come in to work, and they can't come into work because you just don't have work for them. And then that's going to qualify or open up the argument to the employer that they don't have to pay any of this FFCRA leave because the employee is being asked to stay home, and therefore the employee would not be eligible for the paid sick leave. Anything to add on that, Mike or Ann? We have a few more questions I'm going to try to get through here at this point too.
Nope.
Does the sick leave and family leave apply both full-time and part-time employees? Yes, it does.
Yes, it applies to both.
Yep. Yeah, and you calculate how much they're owed. If it's part-time, you do an averaging over a 2-week period. The Department of Labor has some good FAQs on that. We can cover that if anybody has a question on that outside of the webinar here. How is a fine?
I know, Andrew.
Sure, go
Anthony,
ahead.
I know there was a question on how do you get the tax credit at the end and to get reimbursed for it. As we understand it, you can deduct from the payroll withholdings that you owe for the quarter that the leave is used. So unfortunately, it would have been nice if they could say that you can, for the first quarter payroll withholdings that are due at the end of April, you could take from that. But under the law, it has to be from the quarter that the leave was taken in. So April, May, June, those quarterly withholdings you could deduct against the payroll withholdings that you would have to pay at the end of the quarter to cover that. And to the extent there's a short change, they're going to have a form that they say that they can turn around checks to you in 2 to 3 weeks. We'll see.
Okay. Good question here. How's the 500 employee threshold calculated? For example, if I have 3 entities with 200 employees each, would I be required to provide the paid leave?
Possibly. It's a test. It's the integrated employer test. There's 4 different factors, and it's really kind of the totality of the circumstances as to the overlap of the operations, common ownership, common management, and essentially as to whether the different entities are kind of controlled together as one, more so than a normal parent-subsidiary relationship. So in that case, you may want to talk to counsel because it's not a bright line test, and it's critically important to know whether you meet the exemption or you don't.
Yep. Good question here. And I know, Mike, I've talked to you about this a little bit. We've brainstormed about it, but it's a really good question. What if the school year ends on June 1st? Does the emergency FMLA stop when the school year ends? And I think this is one of these questions we don't have any guidance on right now, and this is pure speculation on how this is going to play out. But it's a good question, and I think there's an argument that once the school year ends and the children are home for summer break, that there's an argument that the employee then doesn't have to be at home because the school's not closed anymore, right, Mike?
Right. I agree. One, that we don't know, we don't have enough guidance, but that seems to be a pretty good argument that once the school year ends, you can't claim that the reason the employee can't work is because of the school closure. Now, maybe it just is that the employee has to show that, well, after school closed, I would have had childcare, and now that childcare is not available, and that would qualify as well. But something to think about and seek documentation on.
Yep. No, and that's the other argument I think that would come into play. Normally, I'd have my children in some type of alternative childcare or sports camps or something like that, and maybe those aren't available coming into the summer. So we'll have to see how this plays out, how long the shutdown is going to be, and what that looks like. And then again, if the kids normally go to a sports camp, does that qualify as one of these childcare facilities or not? So it's going to be interesting to see how that plays out. Let me see another couple questions here. Good questions coming in. Did you say if we simply did not schedule them for work, that's like furlough and did not get paid and would not get paid sick leave? I wouldn't just not schedule the employee for work. Again, I'd make it clear that, look, there's a clear separation from work. You're being suspended, furloughed, typically the employer uses that term, and we expect you to return to work once this passes, and make it clear, make that determination. And we've got the law goes into place tomorrow, so if you furlough those employees today or first thing tomorrow, you've got a great argument that you don't have to pay the paid sick leave for those employees that you've furloughed or laid off under the FFCRA.
Yeah, I think it's very important to really kind of communicate very clearly with the employee what is the nature of the situation. Is it a temporary furlough where we expect to have you back? Is it a permanent separation, in which case we got to pay out final wages and unused vacation? But you want to be clear and document it so that there's clear communication as to what the nature of the employment relationship is going forward.
Yep. And then, yeah, that leads to the next question. What if we neither laid off or furloughed formally, just did not put them on the schedule, still exempt from the paid sick leave pay, or needed to give something in writing? And we recommend having this in writing to make it clear. If you just don't put them on the schedule, they could make the argument that they're eligible to work, and then they could qualify for the paid sick leave. You might owe the paid sick leave under that case. So to make it clear to meet what are these exemptions, to meet this clarification that the Department of Labor has issued over the weekend, that if you have furloughed the employee or closed a location, or you don't need the employee right now because of lack of work, you don't have to pay the paid sick leave. And I think you need to document that clearly to employees at this point in order to not have the requirement of paying this paid sick leave under the FFCRA. Does a layoff qualify the employee for unemployment? It does. And actually a reduction in hours of work right now does qualify them, the employee, for unemployment. And the California is making it really easy for the employees to get unemployment right now too. Please confirm that a layoff is not a termination, that we can keep them on payroll as a result of lack of work. That's correct. When you say keep them on the payroll, keep them on the books. Yeah, they're still considered an employee, but they're not getting any work. But they're being furloughed. It's typically what the employers are using that term to mean. But clarify that and have that in writing. If you're furloughing them. A layoff typically is considered that there's an end of employment and they're no longer an employee for the employer, but they could still be rehired by the employer down the road. So you need to be careful and clearly communicate what the expectation. Don't just use these terms thinking that everybody understands what all these terms mean. They can mean a lot of different things in a lot of different contexts. So you explain to the employee what's exactly going on. If they're going to be considered terminated, they're laid off, and they're not considered an employee, or are they being furloughed, just suspended temporarily because of lack of work, and then they're going to be rehired down the road, or not rehired, but given work down the road. So you need to clarify that going forward. I think that's the best way to go.